The United States Supreme Court has just dropped a bombshell 6-3 ruling that is sending shockwaves through every immigration courtroom, every border checkpoint, and every federal agency in this country. And if you are a green card holder, if you have family members who are lawful permanent residents, or if you care at all about how this country enforces its immigration laws, then you need to stop what you are doing right now and pay close attention, because this decision fundamentally changes the landscape. In a case called Johnson v. Arellano Garcia, the Supreme Court, in a decisive 6-3 opinion authored by Justice Amy Coney Barrett, has just ruled that federal immigration authorities have significantly broader power than most lower courts had previously recognized to detain, process, and initiate removal proceedings against non-citizens, including lawful permanent residents, at the border and at interior checkpoints, without the kind of robust judicial oversight that immigration advocates have spent decades fighting to establish and protect. And here's the thing that makes this ruling so explosive. It is not just about one person, it is not just about one border crossing, and it is not just about one isolated set of facts. This ruling sets a nationwide precedent that reaches into every immigration court in America. It affects the procedures that govern millions of people who are living legally in this country right now. It reshapes the relationship between the judiciary and the executive branch when it comes to one of the most politically charged issues of our time. And it does all of that in a legal opinion that the conservative majority on the court says is completely, entirely compelled by the plain text of the federal statutes that Congress passed. The liberal wing of the court, predictably, has come out swinging hard in dissent. Justice Sonia Sotomayor filed a blistering dissenting opinion, joined by Justices Elena Kagan and Ketanji Brown Jackson, accusing the majority of essentially handing the executive branch a blank check to steamroll the due process rights of people who are supposed to have the full protection of American law. And they are not pulling punches. They are arguing that today's decision is going to have devastating real-world consequences for hundreds of thousands of people who did nothing wrong, followed the rules, built their lives here legally, and are now far more exposed to the machinery of the federal immigration enforcement apparatus than they have ever been before. So, today we are going to break down exactly what happened in this case, what the Supreme Court actually ruled, what the two competing legal philosophies are that were at war on this court, and most importantly, what this means for you, your family, and the country going forward. We are going to go through all of it step by step. But before we get into all of that, if you are new here and this is the kind of content you want to see more of, breaking down major court decisions, explaining what they actually mean in plain English, cutting through all of the noise, then make sure you hit that like button right now. Make sure you subscribe, and most importantly, make sure you turn on all notifications so that when I release this content, you are the first person to see it. I put a lot of work into these breakdowns, and I want to make sure you are getting them as soon as they drop. I also want to take a moment to thank the main sponsor of today's video, which is Attorneys on Retainer. Now look, we talk a lot on this channel about legal rights, about what the government can and cannot do, about how the law affects your everyday life. And one of the things I genuinely believe is that every person in this country should have access to real legal counsel when they need it, not just the people who can afford to pay an attorney $300 an hour every time they have a question. That is exactly what Attorneys on Retainer is built to solve. They are an actual law firm. Not an insurance company, not a referral service. A real law firm staffed by experienced attorneys who specialize in self-defense law, constitutional rights, and protecting members who find themselves in a situation where they need legal help fast. I have been a member, I have looked at what they offer, and in my opinion they genuinely are one of the best options on the market right now if you want the kind of legal protection that gives you real peace of mind. So if you want to check them out, the link is down below in the description. And right now, for a limited time through the end of the month, if you use my exclusive code ARMSCHOLAR, you can get $50 off your individual sign-up fee or $25 off the family plan. Go check them out. Use the link below. Use the code. All right, now let's get into this ruling. To understand how Johnson versus Arellano Garcia ended up in front of the Supreme Court and why it matters so much, we have to go back and look at the specific facts that gave rise to this challenge, because the facts here are actually very important for understanding just how far-reaching the court's legal reasoning is going to be. The respondent in this case, Mr. Miguel Arellano Garcia, is a citizen of Mexico who came to the United States legally and eventually obtained lawful permanent resident status, a green card, back in 2009. He has lived in the United States for over 15 years. He has a family here. He has built a life here. By all accounts, for the vast majority of that time, he was living exactly the kind of quiet, law-abiding existence that the immigration system is supposed to protect when it grants someone permanent resident status. Now, in 2019, Mr. Arellano Garcia was driving back across the border at a port of entry in California after a short trip to visit relatives in Mexico, a trip that lasted, we are talking, about 4 days. This is exactly the kind of brief trip that green card holders take all the time. Under federal immigration law, specifically under the Immigration and Nationality Act, lawful permanent residents who take short, innocent, casual trips abroad are supposed to be treated as if they are seeking admission for the first time in only the most limited of circumstances. The statute essentially presumes that a green card holder coming back home from a short trip is already an admitted resident, not someone applying for admission from scratch. Here's where things get complicated. When Mr. Arellano Garcia presented himself at the port of entry, Customs and Border Protection officers flagged him in their database as having had a prior contact with law enforcement. Specifically, there had been an arrest, not a conviction, an arrestee, in 2017 related to a low-level drug possession charge that had ultimately been dismissed. No conviction, no guilty plea. The case had been thrown out, but the arrest was still in the database. Based solely on that database flag, based on that prior arrest, a CBP officer made the determination on the spot that Mr. Arellano Garcia fell within one of the statutory exceptions that strips a returning resident of the default admission presumption. The officer took the position that Mr. Arellano Garcia had potentially committed a controlled substance offense and therefore could be treated as an arriving alien seeking admission rather than as a returning permanent resident entitled to the protections that come with that status. His green card was confiscated on the spot. He was given temporary parole documentation. Formal removal proceedings were initiated against him. And just like that, after 15 years of living here legally, Mr. Arellano Garcia was suddenly in the immigration removal pipeline, fighting to stay in the country he calls home. Now, naturally, he challenged this. His legal team argued that a dismissed arrest, an arrest that resulted in no conviction, no guilty plea, nothing, simply could not be sufficient grounds to strip a lawful permanent resident of the protections guaranteed to him by federal statute. They argued that the CBP officer acted without any constitutionally and statutorily adequate basis when he made that snap determination at the border. An immigration judge initially sided with the government. The Board of Immigration Appeals also sided with the government on review. But then Mr. Arellano Garcia appealed up to the Ninth Circuit Court of Appeals. And this is where things really got interesting. The Ninth Circuit reversed the lower rulings in a very significant decision. The Ninth Circuit held that a bare arrest record, an arrest that never produced a conviction and that was in fact dismissed, is constitutionally and statutorily inadequate to justify treating a returning lawful permanent resident as an arriving alien subject to full admissibility review. The Ninth Circuit said that to allow that would be to eviscerate the statutory protections that Congress specifically built into the Immigration and Nationality Act for people in exactly Mr. Arellano Garcia's position. The Ninth Circuit's ruling created a direct and undeniable split with several other federal circuit courts that had ruled the other way on virtually the same question. And that circuit split, that conflict between different federal courts reaching opposite conclusions on an issue that affects millions of people, is exactly the kind of thing that sends a case straight to the Supreme Court's front door. The government petitioned for certiorari, the Supreme Court granted it, and just recently, in that 6-3 decision, the Supreme Court completely reversed the Ninth Circuit. The majority opinion, what Justice Barrett actually held. Justice Amy Coney Barrett, writing for the six-justice conservative majority, approached this case through what you might call an aggressively textualist lens. And I want to walk through the core of her reasoning carefully, because it is important to understand not just what the court decided, but how it got there, because the how is going to matter a lot for how this ruling gets applied going forward. The majority started from the statutory text of the Immigration and Nationality Act. The specific provision at issue deals with when a lawful permanent resident can be treated as an arriving alien. In other words, when can the government strip away that presumption of admission and subject a green card holder to the full scrutiny that a first-time entrant would face? The statute says this can happen when the returning resident has committed certain categories of offenses, including crimes involving controlled substances. Barrett and the majority zeroed in on that word committed. The statute does not say convicted of, it does not say adjudicated guilty of, it does not say entered a guilty plea to, it says committed. And the majority's argument is straightforward. Committed means committed. It means the act occurred. A conviction is a legal determination made after the fact by a court. The act of committing an offense is a separate and distinct thing from the legal status of having been convicted of that offense. And because Congress chose the word committed rather than convicted, the majority held that Congress intended to give border officers the authority to make a threshold determination based on whether an offense appears to have occurred, not based on whether a court has already formally adjudicated the question. Now, the majority went further than just the word choice. Justice Barrett laid out what is essentially a two-tier framework for how this is all supposed to work. Tier 1 happens at the border, in real time. At that stage, all the government needs to do is establish a reasonable basis to believe that one of the disqualifying statutory offenses may have been committed. That is a relatively low bar. It is not proof beyond a reasonable doubt. It is not clear and convincing evidence. It is a reasonable basis, closer to what you would recognize as a reasonable suspicion or probable cause standard, but applied in the administrative immigration context. Tier 2 is the actual formal removal hearing, which comes later and involves the full procedural protections of immigration court, an immigration judge, legal representation, the opportunity to present evidence and challenge the government's case. And at that stage, the government does have to meet a significantly higher evidentiary burden. It has to prove its case by clear and convincing evidence. All of the due process machinery kicks in at step 2. Barrett's argument is essentially this: the Constitution and the statute both recognize that the border is a unique environment. Border officers are making real-time decisions, often with limited information, in a high-stakes environment where the government has a compelling interest in controlling who enters the country, requiring them to make final, court-quality evidentiary determinations on the spot before they can exercise any enhanced scrutiny over a returning resident would make the entire statutory framework unworkable. Congress knew this. Congress drafted the statute accordingly, and courts have no business reading a higher evidentiary standard into the statute when Congress did not put one there. The majority also rejected the argument that a dismissed arrest is, by definition, insufficient evidence of the commission of an offense. Barrett acknowledged that a dismissal means there was no conviction, but she pointed out that a dismissal does not legally establish that the conduct never occurred. A case can be dismissed for any number of reasons: prosecutorial discretion, evidentiary problems, a deal, witness unavailability, that have nothing to do with the question of whether the underlying conduct actually happened. So from the majority's perspective, a border officer looking at a prior arrest on a serious controlled substance charge is not acting unreasonably or unlawfully by treating that arrest as some evidence that the relevant conduct may have occurred. Put all of that together, and you get a ruling that significantly expands the practical authority of Customs and Border Protection officers at ports of entry. Under Johnson versus Arellano Garcia, those officers now have clearer legal authority, and importantly, clearer legal cover E, to exercise enhanced scrutiny over returning lawful permanent residents based on a much lower evidentiary threshold than several circuit courts had previously required. The nationwide implications of this are substantial. We are talking about millions of lawful permanent residents in the United States who travel internationally and who now face a legal environment where their re-entry into a country where they have legally lived for years can be subjected to significantly more aggressive scrutiny based on information that has never been tested in any court. The dissent, what Justice Sotomayor said. Justice Sonia Sotomayor's dissent is long, it is detailed, and it is sharp. She was joined by Justices Kagan and Jackson, and the three of them are clearly furious about this decision. Sotomayor opens by making a fundamental point about who is actually affected by this ruling. These are not people trying to sneak across the border. These are lawful permanent residents, people who went through the legal immigration system, got vetted, got their green cards, have been living here legally. The whole point of lawful permanent resident status under federal law is that you are supposed to have a stable, protected immigration status. You are not supposed to be vulnerable to having that status yanked away by a border officer making a snap judgment based on a record that a court already dismissed. The dissent attacks the majority's textual argument head-on. Sotomayor argues that the majority's reading of the word committed is not as self-evident as Barrett claims. She points out that across federal law, when Congress wants to trigger consequences based on criminal conduct, it routinely ties those consequences to convictions, specifically because the conviction is what provides the procedural guarantee that the conduct actually occurred in a legally verified way. To say that committed means simply the act may have occurred based on a border officer's review of a database is, in Sotomayor's view, to drain the word of the legal meaning that Congress almost certainly intended it to carry. But the dissent goes beyond the textual argument and makes a due process argument that is really at the heart of what the liberal justices are most concerned about. The dissent argues that what the majority has now sanctioned is a regime where the government can act first and justify later, where a border officer can make a consequential, life-altering determination about a legal resident's status based on thin, untested, and in this case factually incorrect information, and that person then bears the burden of fighting their way through the immigration court system to get their status restored. And in the meantime, their green card is gone, their immigration status is in limbo, and they are navigating what can be an incredibly slow and resource-intensive legal process. Sotomayor hammers on the practical consequences. She talks about what it actually means for a lawful permanent resident to have their status put into limbo by a border determination. She talks about the difficulty of maintaining employment, of securing housing, of opening bank accounts, of just living a normal life when your immigration documentation has been confiscated and replaced with temporary parole paperwork. She talks about the emotional toll, the terror of not knowing whether you are going to be allowed to stay in the country where your family lives, where your children go to school, where you have built everything. And then Sotomayor makes what is perhaps the most pointed argument in the dissent. She says that the majority's ruling is not just about statutory interpretation, it is about the allocation of power between the branches of government. She argues that the Supreme Court has now handed the executive branch, specifically Customs and Border Protection and the Department of Homeland Security, an enormous amount of discretionary authority over the liberty of legal residents with almost no meaningful check from the judiciary at the point where it matters most, which is at the border, in the moment when someone's status is being stripped away. And she argues that history teaches us that this kind of unreviewable executive discretion, exercised against vulnerable populations, has an ugly track record in this country. What this means going forward, the big picture. So, what does all of this actually mean in practice? Let me lay out a few things here that I think are important for people to understand. First, this ruling is going to have immediate and concrete effects at ports of entry nationwide. CBP officers now have a much clearer legal framework, one blessed by the Supreme Court, that authorizes them to exercise enhanced admissibility screening over returning lawful permanent residents based on a lower evidentiary threshold than courts in many circuits had previously been applying. Expect to see that authority used more aggressively, particularly in the current enforcement environment. Second, this ruling is going to affect the strategy of immigration lawyers across the country. If you have a lawful permanent resident client with any kind of prior law enforcement contact in their history, even a dismissed case, even a sealed record, even an old arrest that went nowhere, you now have to counsel them very carefully about the risks they face every time they travel internationally. What was previously a manageable risk just became significantly more significant. Third, and this is important, the ruling does not eliminate due process at the removal hearing stage. The majority was very clear about that. The government still has to prove its case by clear and convincing evidence in immigration court. So for people who find themselves on the wrong end of an enhanced border determination under this new framework, the immigration court proceeding is still where the real fight happens. The rights are still there. They are just pushed back to a later stage, which, as the dissent notes, is cold comfort for someone whose green card has been confiscated and who is sitting in immigration limbo while that process unfolds. Fourth, expect this ruling to become a major flashpoint in the broader national debate about immigration enforcement. The court has essentially moved the law in the direction of giving enforcement agencies more front-end flexibility, and that is going to have political consequences on both sides of the issue. Advocates and legislators who want tighter restrictions on executive immigration authority are going to point to this ruling as exactly the kind of judicial green-lighting of expanded executive power that they have been warning about. And advocates and legislators on the other side are going to point to it as a common-sense affirmation of the government's legitimate authority to control who enters the country and under what circumstances. Fifth, and this is the thing I want you to really sit with, what this ruling illustrates more than anything else is the enormous stakes that come with the composition of the Supreme Court. 6 justices aligned with a textualist, executive power-respecting judicial philosophy just changed the law for millions of people with a single opinion. 3 justices with a different legal philosophy wrote 60 pages arguing that this is a disaster for due process and individual rights. The court is 6-3. That math matters. That math is going to keep mattering for years, probably decades. So that is the ruling. Johnson versus Arellano Garcia, 6-3, Supreme Court of the United States, a decision that is going to be cited, debated, litigated around, and legislated around for a very long time to come. Now I want to hear from you, because I think this case actually raises one of the most genuinely interesting and contested questions in constitutional law. On one side, you have Justice Barrett and the majority saying, look, we are just reading the statute the way Congress wrote it. The word is committed, not convicted. Courts are not supposed to add words to statutes that Congress left out. Border officers need practical flexibility to do their jobs. And there is a full due process hearing available down the line for anyone who challenges the government's determination. That is the rule of law working the way it is supposed to work. On the other side, you have Justice Sotomayor and the dissenters saying, a dismissed arrest is constitutionally and legally meaningless. A border officer should not have the power to upend a legal resident's life based on a database record that a court already threw out. The whole promise of lawful permanent resident status is that it provides stability and protection, and that promise is hollow if it can be taken away in 5 minutes at a port of entry by a single officer with limited information and essentially no real-time judicial check. So here's my question for you. I want to know what you actually think. Do you believe that Justice Barrett and the majority got this right? Is this a legitimate and faithful application of the statutory text that Congress wrote? Does the government have a compelling interest in border-level flexibility that justifies this outcome? Or do you agree with Justice Sotomayor and the dissent that this ruling flips due process on its head, that it gives the executive branch too much unchecked power over the liberty of people who are supposed to have the full protection of the law? Let me know exactly where you stand down in the comments. I read every single one of them, and I genuinely want to know what you think. And look, if you made it all the way to the end of this video, you are exactly the kind of person this channel exists for. You want to understand what is actually happening in American law and politics. Not just the headlines, not just the hot takes, but the actual reasoning, the actual arguments, the actual stakes. So if that resonates with you, please do me a favor. Hit that like button, subscribe if you have not already, and turn on all notifications so you never miss one of these breakdowns when I drop them. As always, thank you so much for all of your support. This community continues to grow, and I could not do any of this without you. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.